Margaret Ellison was 73 years old when the bulldozers came for her orchard. She had lived on the same 12 acres outside Millbrook for 46 years, ever since she and her husband Walter had planted the first row of apple trees as newlyweds. Walter had died 11 years earlier, but the orchard remained. 300 trees of Honeycrisp, Gala, and heirloom varieties Walter had grafted himself, along with a small stand of pear and peach trees near the creek. The trouble began when a development company called Ridgeline Partners bought the adjacent parcel to build a subdivision of 40 luxury homes. Margaret's property sat between Ridgeline's land and the county road, and for months a company representative named Curtis Vance had been pressuring her to sell. She refused every offer, the last one absurdly low at half the land's actual value. "This orchard is the only thing I have left of my husband," she told Vance the final time he visited. "I am not selling it, and I would appreciate it if you stopped asking." She ran outside in her robe, screaming for them to stop. The foreman, confused and apologetic, showed her a work order with a parcel map. The map showed the wrong boundary line, shifted nearly 80 feet onto her property. Ridgeline's surveyor had made an error, or perhaps not an error at all. By the time the crew halted work, they had destroyed 61 trees, including the very first row Walter had planted, and had crushed the toolshed where Margaret kept his gardening equipment. Margaret did not simply cry and accept an apology. She called her nephew, a paralegal in the city, and within 2 days she had retained a lawyer named Denise Okafor, a woman who had built her small firm on cases exactly like this one. Property disputes against developers who assumed elderly landowners would fold quietly. Okafor's investigation turned up more than a boundary mistake. Internal emails obtained through discovery showed that Vance had told his supervisor, in writing, that "the old lady won't move, so we start on her side first and let the lawyers sort the lines out later. She won't have the money to fight us." The email was dated 8 days before the bulldozers arrived. That single sentence changed everything. What had looked like a surveying error now looked like a calculated trespass, an attempt to destroy Margaret's orchard and pressure her into selling once the damage was irreversible. The lawsuit that followed took 14 months. Ridgeline's attorneys initially offered a settlement of $80,000, framing the destruction as an honest mistake and the trees as replaceable. Margaret refused. She wanted the truth on record, not a quiet payout. At trial, Okafor brought in an orchard appraiser who testified that the destroyed trees were not simply replaceable. Many were over 40 years old, producing yields no young sapling could match for another 2 decades, and several were the last living specimens of an heirloom apple variety Walter had cultivated himself, found nowhere else. The appraiser valued the immediate loss at just under $400,000, factoring in lost future harvests, restoration costs, and the destroyed equipment shed. But the real turning point was the email. When Okafor read Vance's words aloud in court, "She won't have the money to fight us," the jury's reaction was visible. Margaret, sitting quietly at the plaintiff's table in a blue cardigan, did not react at all. She had waited months to hear those words spoken back to the people who wrote them. Vance took the stand and tried to explain the email as aggressive internal shorthand, insisting the company always intended to correct the boundary and compensate her fairly. Under cross-examination, Okafor asked him a simple question: if the company always intended to compensate her fairly, why did the crew start clearing trees 8 days after that email, without contacting Margaret, without a corrected survey, and without so much as a phone call warning her that work was beginning near her property line? Vance had no good answer. Okafor called 2 more witnesses that week. The first was a longtime neighbor, Harold Rees, who had known Margaret and Walter since the orchard was young. He described watching Walter graft the heirloom rows by hand, splicing scion wood from a tree his own grandfather had planted back in the 1950s, a variety that had never been formally registered or sold commercially. Harold testified that Margaret still followed the same pruning schedule Walter had taught her, walking the rows every February regardless of the weather, because she said the trees didn't stop needing her just because he was gone. It was a small detail, but it humanized the loss in a way the appraiser's numbers could not. The second witness was a former Ridgeline site supervisor who had quit the company 2 years earlier over what he called a pattern of cutting corners on land they didn't fully own yet. He testified that he had seen similar tactics used on 2 other parcels before Margaret's case, though neither of those disputes had ever reached a courtroom. Both settled quietly and confidentially. His testimony could not be used to establish damages for those other properties, but the judge allowed it as evidence of intent and pattern, over strenuous objection from Ridgeline's defense team. By the time closing arguments began, the courtroom had shifted decisively. Ridgeline's attorney urged the jury to see the case as an unfortunate accident compounded by an unwisely worded internal email, insisting the company's later offer of $80,000 proved good faith. Okafor countered simply, "A company acting in good faith does not wait until after getting caught to offer compensation, and it certainly does not write down its intention to exploit an elderly widow's limited resources 8 days before sending bulldozers onto her land." The jury deliberated for 6 hours. When they returned, they found Ridgeline Partners liable not only for compensatory damages, but for punitive damages as well, agreeing with Okafor's argument that the company's conduct was deliberate, calculated to intimidate an elderly widow into abandoning property she had every legal right to keep. The jury awarded Margaret $2.4 million, $380,000 in compensatory damages for the trees, equipment, and restoration costs, and just over $2 million in punitive damages meant to punish Ridgeline for what the jury explicitly called predatory and calculated conduct against a vulnerable homeowner. Ridgeline's attorneys filed an appeal, arguing the punitive damages were excessive. An appellate court reviewed the case 8 months later and upheld the verdict in full, noting in its written opinion that the company's own internal correspondence provided unusually direct evidence of intent to exploit the plaintiff's age and perceived financial limitations, language that made the case something of a local legal landmark, cited afterward in at least 2 other property rights disputes in the region. Margaret used a portion of the settlement to replant the destroyed section of the orchard, working with a horticulturist to graft new trees from cuttings of the surviving heirloom stock, preserving Walter's variety before it could be lost entirely. She built a new equipment shed on the same footprint as the old one, kept the same iron latch from the original door because it still worked fine. She did not spend lavishly. She donated a portion of the award to a legal aid fund that helps elderly homeowners fight property disputes they cannot otherwise afford to litigate, telling a local reporter who covered the case that she never wanted another widow to feel as powerless as she had felt the morning she watched her husband's trees come down. Curtis Vance was fired by Ridgeline Partners less than a month after the appellate ruling. The company's founder issued a public apology to Margaret, though she declined to comment on it beyond a single sentence. An apology doesn't replant a 40-year-old tree, but it's a start. Ridgeline also revised its internal land acquisition policy, requiring an independent survey signed off by 2 licensed surveyors before any clearing work could begin near a disputed boundary. Local news outlets reported the change had already prevented at least one similar dispute the following spring, when a boundary discrepancy on a neighboring project was caught and corrected before a single tree was touched. 5 years later, the replanted section of the orchard bore its first full harvest. Margaret, then 78, walked the rows herself every morning, checking the young trees alongside the old ones that had survived, filling baskets with apples that would eventually become the same cider Walter used to press every autumn. Visitors sometimes asked her about the lawsuit, and she would only say that the money mattered less than the fact that people had finally listened to her, that the record now showed, permanently, what had actually happened on that Tuesday morning in September. The subdivision ridgeline eventually built was constructed entirely on the correct side of the boundary line, its closest house, set nearly 100 feet from Margaret's fence. Some of the new homeowners, curious about the mature orchard next door, became her customers, buying apples and preserves from a small stand she kept at the end of her driveway, the same stand Walter had built decades earlier, repaired now, and then, but never replaced, standing exactly where it always had, weathered but sturdy.